Welcome to Pretty Lies and Alibis. Join us as we seek the truth and travel the long road to justice.
Hey guys, it's just Fruit Loop. Gigi is out and about, and our schedules couldn't correlate today, so we are. I'm solo, and she's traveling this weekend, so we may be solo again tomorrow. Um, so before we get started, we want to get a shout out to our sponsor, twocooltshirtquilts.com. / Pretty Lies and Alibis. That's where you go to get you a cool quilt. They do awesome work. Andrea over at Two Cool T-Shirt Quilts. They're awesome. My pillow's not back here because it's on my bed. But they can take your T-shirts and make them into a quilt that is too cool. And remember, they can take old clothing and other things. So check their website out and give them a shout out. They do awesome work. Um, so, what you know? Gigi's not here to ask me, so I had to ask myself. Fruit Loop, what you know? So, did you know that it would take only 1 hour to drive to space? I was like, what? If you got into your car, turned on the ignition, and drove up to the sky at 60 miles an hour, it would take just 1 hour to get to outer space. So I'm thinking, how did they know that? Um, but that is according to astronomer Fred Hoyle, and it's theoretical, but it's crazy to think about, right? So, some of you guys got the Vine link for Letitia Stalk yesterday. Um, I know I did, and was like, what? And I think there was some confusion. It stated that Letitia Stalk was placed on unsupervised custody status on 323, and people were freaking out that she was like left the jail, she was free. There was actually some posts on social media saying they called the jail and she's not. I think all that relates to is she was under supervised. She had to be supervised 24/7, I think, in her cell and wherever she was in the jail. So I think that's all that relates to is they've now removed that. Also, somebody made a good point. She's having a mental eval, so it could be that she's going to do that. So we will we will see. So the big thing, motion to dismiss yesterday. Sorry we didn't get on last night. We just had scheduling conflicts. We have a lot going on, so both of us sometimes can't be together. So Archibald, this was a big thing. Archibald was on screen until the hearing went into breakout, and Rob Wood was as well. Um, so if you know, Archibald has not been on there prior to yesterday. So is she coming back? We don't know, but that was interesting. And then Rob Wood wasn't back on there, but it could have just been scheduling conflict. He may have had something else to do. So Boyce says how we got here is there was a motion to dismiss filed on June 21st, 2021, and goes through the extensions and essentially why it took so long to get to a hearing. The state asked for a continuance, but Boyce allowed arguments to be made today, and supplemental submission of briefing is due by April 20th. Boyce, then they went to a breakout session, which I hate. It's so boring because you sit there and count all the things on the screen. Um, so they went into breakout session to discuss the scope of what should be referenced. Sorry. I know I was sick a few weeks ago. I didn't mean to get that ice in my mouth. And I have this lingering itching in my throat. So, anyways, so Boyce then calls for a breakout session to discuss the scope of what should be referenced publicly for jury. Um, uh, I just had a loss of my brain, just went blank. So Boyce comes back on camera after about 15 minutes, and it looks like he had had a snack. You got to eat, right? So here we go with Pryor. And Chad was on camera. He was looking his stoic, statue, I don't know, face. And I agree with you guys. Sometimes somebody needs to nudge him to make sure he's still alive because he gets sitting there so still. He doesn't even blink sometimes. Okay, that's it. The next time we have a hearing, you got to count how many times Chad blinks. So Pryor goes in and says, "My argument will be brief." I provided a 55-page memorandum with 2 accompanying briefs. The motion to dismiss is based on impaneling a fair and impartial grand jury. I have no intention of disclosing the specifics. I asked the court to see my brief. Um, Extensive media coverage plays into the fairness and impartiality of the grand jury proceedings. I understand what he's saying. We've had bigger cases, bigger than this, like celebrities or whatever, or just cases that are really large, like the one Gigi followed, Jodi Arias. All those are big cases, and they did have media presence. But I still think, um, I think people can be fair. I mean, that's our country, right? Um, so you have to be able to sit and listen to the evidence and say, okay, even though I do know some things, it doesn't play a role in me making a decision about what's been presented in front of me. So the prosecutor chose to use the grand jury. I did not choose that. They could have impaneled a preliminary hearing. They have an obligation and duty to impanel a fair and impartial grand jury. My position is that that was not done. The potential sentence in this case is death. Regarding the memorandum about the venue, you cited that death is different. When you're considering the validity or impartiality of the grand jury proceeding, you have to take into consideration the consequences and results of that. There needs to be a higher scrutiny and higher review of the standards that are set forth and given that I implore the court to look at. He implores the court to look at what he's laid out in his brief and strongly consider, at least from my perspective. I understand what he's saying about death is a serious thing, but for me, anytime you're in a court of law, it's serious. I don't care if you stole juju beads from the gas station and you're being tried. I think it should be the same top to bottom when that's being done. Just because it's death on the table, for me, doesn't change anything. It's all serious. Um, so I lost a place. I'm asking the court to take as part of this the complete record of the grand jury proceedings to incorporate my brief and memorandum filed on the 8th and the 2 accompanying briefs as they relate only to the grand jury proceedings. I think if you take the opportunity to review my extensive briefings, I would ask the court to dismiss this indictment on that basis. So we don't know what's in his brief. I think that was sealed. Gigi's not here to answer that, but I think it was sealed. So Lindsay Blake comes back and says, as the court mentioned at the outset of these proceedings, we have not been able to get our brief submitted to the court. So they were slow in getting it back. At the time this hearing was set, Mr. Pryor was given 30 days to submit his brief to the court. And we know Pryor filed his in a timely manner, a day early, but we didn't look at the timing of that closely, and that left the state with 2 weeks and 1 day from the time we got it to this hearing today. So basically, she's saying they didn't have time. So in order for us to get a brief together and Mr. Pryor to have that brief and have enough time to review, that's why the state asked for the continuance. The court said we could supplement any argument with briefing. We would indicate to the court we've been working diligently. Sorry, guys. Diligently on this and would intend to supplement the argument today with that brief. She goes on to ask the court, would they set a timeline of when that would be due? And Boyce says, he asked, would 2 weeks work? And Blake said they hope to have it submitted at the beginning of next week. Boyce says April 6th at 5 p.m. is the due date. She asked about a reply deadline for Pryor, and Boyce says April 13th. But then Pryor said he anticipates a lengthy rebuttal and asked for an additional week. So Boyce said the 20th is the deadline for Pryor's rebuttal brief. Guys, it's crazy, right? So they get into some Idaho criminal rules that deal with grand juries. and deal with the grounds in which an indictment can be dismissed. A valid challenge to an individual juror who served on the grand jury who found the indictment except the finding of a valid challenge to one or more members of the grand jury is not grounds for dismissal of the indictment if there are 12 or more qualified jurors concurring in the finding of the indictment. So she quotes some more code that the people or persons held to answer a charge for a public offense may challenge the panel of a grand jury or an individual juror. And that was Idaho Code 19-1001. So another Idaho code outlines the very specific grounds for challenge to a panel. And then when we turn to Idaho Code 19,003, that's where we get the outline for the grounds to challenge an individual juror that served. The focus of the defense has been subsection 6 and 7 regarding 6, that he has formed an unqualified belief or opinion that the defendant is guilty or not guilty of the offense charged, but a hypothetical opinion founded on hearsay or information supposed to be true, unaccompanied with malice or ill will, shall not disqualify a grand jury or be cause of challenge. So then she goes on to say, in part of that, in 7, that a state of mind exists on his part in reference to the case or to either party, which satisfies the court that he cannot act impartially and without prejudice to the substantial rights of the party challenging. So more code. It's crazy. It gets on your nerves, right? So another Idaho code lays the grounds for setting aside an indictment and includes very specific reasons for which a challenge or indictment could be set aside. There are 4 different challenges laid out. In looking at number 4, when a defendant has not been held to answer before the finding of the indictment on any ground which would have been grounds for challenge either to the panel or any individual grand juror. Between the criminal rules and the statutes, there is some overlap when looking at challenges to an indictment, and one of the common themes that comes up is a challenge to the individual grand juror or the panel of the grand jury. And that's been the focus at this point in time in the defense request to dismiss the indictment. She cites a case where it says the grand jury is an accusing body and not a trial court. Its functions are investigative and charging. The purpose of the grand jury is to see if sufficient probable cause exists to bind the defendant over for trial. The determination for guilt or innocence is saved for a later day. If you remember, Chad or Pryor, none of those are in there. Hey guys, all you alibis. Now it's time to feature our paid sponsor for this week, June's Journey. June's Journey is something that our listeners will love. You guys, I really think you'll love it. It's perfect if you're craving a good mystery or you just need to get away for a little while. Take a journey into the roaring 20s as Detective June Parker. As you approach each case, you get the chance to search for hidden clues in a really awesome graphic-oriented style game. Guys, the graphics in this thing blow you away. There are new cases every week, and with over 30 million downloads, June's Journey is definitely popular. It's an engaging game, and it definitely draws you in. It's like draw me in. I get obsessed with it. Like I just want to play it. It's just so relaxing, and I unwind with it. There's a detective in all of us. Find your inner detective. Download June's Journey free today on the Apple App Store or Google Play. As long as a grand jury has received legally sufficient evidence that in and of itself supports a finding of probable cause. In addition, in the case, and she cites a case, Edmondson, the court noted that dismissal is a drastic remedy and should only be exercised in extreme and outrageous situations, and therefore the defendant has a heavy burden. So one thing brought up by the defense is an allegation of prosecutorial misconduct. The state's position is there was none that'll be outlined more clearly in our brief. State versus Forbes says that if legally sufficient evidence was presented that the indictment should be dismissed, the misconduct must be so egregious that it has a guys, I cannot talk today. Prejudicial effect on the proceeding. It also says in reference, inference should be in favor of the indictment. So in a case, she quotes another case, Silverthorne versus the U.S. It also says the grand jury deliberates and indicts as an accusing body on the standard of reasonable probability that a crime has been committed. It is not a trial body. So the amount of evidence is not as great as the evidence to convict. If the grand jury is prejudiced by outside sources when there's insufficient evidence to indict, the greatest safeguard to the liberty of the accused is the trial jury and the rules governing its determination of a defendant's guilt or innocence. I think the big thing, this wasn't a conviction, this wasn't a trial. This is just to say, okay, this is what evidence we have. Do we have enough evidence to go to trial? She said she cited this case because throughout the defendant's brief, the Idaho Code and criminal rules that were cited deals specifically with impartiality or implied bias on the part of a trial jury and not a grand jury. She said she is unaware of any case law that would make that applicable to a grand jury. In that Silverthorne case, the trial jury is a remedy with any defect regarding an indictment. So there's more rules. She talks about, in part, that the district judge is in charge of impaneling a grand jury and determines if the jurors are qualified to serve. Idaho Criminal Rule 61B is where the prosecuting attorney has the duty to inquire if a juror is to be disqualified. Voir dire, that's one of those funny words. I probably just messed it up, but y'all know how we roll on those. For a grand jury is very different than that of a trial jury. Under Idaho criminal rule, there is no right that the prosecuting attorney has the opportunity to conduct voir dire. Sorry. In this situation, and I know y'all will send a message saying I messed it up. It's okay though. I like to hear from you. In this situation, the prosecutor did have the opportunity, but it is not specifically the prosecuting attorney who has the right or the duty at the commencement of the presentation of an investigation. That's in part because the grand jury may sit and hear multiple cases, and each case may be different. A grand jury may have a disqualification for one case, but be able to sit for other cases. So Boyce chimes in here. Sorry. And says that an important point to consider because in a trial with jurors, you have a vetting of those jurors through voir dire conducted by both sides, and in a grand jury proceeding, the defense is not present. There needs to be some kind of gatekeeper function to be sure you have fair and unbiased jurors that sit as grand jurors. And Pryor, if you go back and look at the video, Pryor nods in agreement. So this is Boy. So you're saying under Idaho Rule 1003, that was a Southern term, 1003. There's a different standard applied to challenging grand jurors. We wouldn't call it voir dire, but essentially vetting those jurors that would not be qualified. So Blake says, yes, when you look at those specific rules, they actually outline different reasons for which a challenge can be made to a juror. So 19-1003 has 7 different challenges outlined which can be brought to challenge an individual juror. The defense brief outlines Rule 19-2020, where it outlines the challenges for a trial juror, where the challenges allowed are different. This isn't a trial jury. It's not a trial jury, juror, whoever. It was simply the grand jury. In looking through case law, it appears a large part of the difference is that the grand jurors are just an investigative body and only making a probable cause determination. The challenges are different between the two juries. Totally agree. Boyce says, so you're saying it's a lower standard to seat a grand jury than a trial jury? Blake says, yes, because there are other remedies available short of dismissal or setting aside a verdict. With a grand jury, there's other remedies available, and one that is constantly outlined in case law is to let a trial jury hear all the evidence. Guys, I apologize. Blake says they don't want to go too deep into it since the grand jury is a sealed proceeding, but from their review of the grand jury transcript, the court did repeatedly ask follow up questions to groups and individuals who raised their hands in response to a question. Oftentimes, those questions were about the jurors' ability to remain open minded, fair, and impartial. Our position is that the district court and the state conducted appropriate, followed up when necessary to ensure an impartial and unbiased jury was seated. Guys, I don't think they, I don't know. I trust, one, I trust our court system, but two, Wood and Blake, they want to get Chad and Lori as much as anybody else. This is a big case for them. In State versus Dunlap, the court dealt with capital cases, and it says while there is no absolute constitutional right to individual voir dire in capital cases, the method must align with due process requirements. In the brief, there is an argument of the potential of jurors having a relationship with a party or witness, and she cites State versus Velasquez, where they analyze relationships between grand jurors and the prosecuting attorney and whether that was a basis for disqualification. She cites another case where the court upheld the trial court's denial of the challenge for cause of a prospective juror who, at the time of trial, was employed by the prosecuting attorney as a janitor. It said the relationship must be between the accused and the juror. So there's your connection. It said the relationship must be between the accused and the juror. She gave a couple more examples of relationships and how the court ruled the proper standard was applied in denying the motion to dismiss. Blake says there were several arguments made by the defense about individual jurors, and the state believes they were appropriately seated. As long as there remains 12 jurors that return a unanimous indictment, which Idaho has 16, the indictment would stand. Another argument is that there's an incomplete record of the grand jury proceedings. All proceedings must be recorded except the deliberations. Pryor says the recordings were stopped at times. The state believes they were properly recorded. We can't find any law saying the recording must continue if sidebars are taking place or if the parties are entering a break. That's common knowledge, right? Why would you continue to record if there's been a break? We can't find any law saying the recording. Oh, I just said that. If the indictments were set aside, it is not a bar to a future prosecution for the same felony offense. It bars if it's a misdemeanor but not a felony. Boyce comes in and says the sufficiency of the record. There's a part of Pryor's briefing where he says the defense should be entitled to the voting roll, but also the juror vote should be identified by name. Blake says Pryor can review the voting records. Pryor comes back and says her argument centers around the evidence presented. My argument is the fairness of the grand jury itself. And here we go back to that same thing. It's not fair. Media coverage has blown. Dude, what the world? That's a big what the world. We're in 2022. Media coverage is everywhere. Social media is everywhere. They're going to hear about your case. Pryor says, I will rest on the contents of my brief. I do not want to say they don't get to decide what portion of the proceedings I get or request. He says, Chad is entitled to the grand jury proceedings. I feel there hasn't been a complete record provided to me. It's not me requesting additional info. If I want to challenge any juror for cause, I shouldn't have to request that information. I should be able to know who they are if I am challenging a juror. The state has to provide me all discovery, and there will be motions addressing that. Oh no, here come the motions. The motions bus. The majority of the cases she addressed were sufficiency of evidence, not the sufficiency of the grand jury. Well, his stuff was on a trial jury, and it's not a trial jury. Come on there, Pryor. The grand jury impaneled was not fair and impartial. I think you could have taken the evidence in front of a kindergarten class, and they would say, okay, yeah, we can go to trial. So Blake comes back and says, we have no problem providing names. The problem is the grand jury proceedings are secret and there are rules governing those. Like, Pryor, you want to change those? Oh, let's change the rules? You can't do that. So Boyce says, I will order there's an authorization for the voting records to be given to Pryor. That's the only ruling for today. I will take the issue under advisement and submit a written ruling. So, guys, that's what we're waiting for, the written ruling from Judge Boyce. And we don't know when that's coming. But me personally, I think we're okay. I think it's going to be okay. The grand jury is not a trial jury, so there's different rules, and that's solely my opinion. And all this is for entertainment purposes only. But sit back, let's just chill, wait on Boyce's ruling, and we will go from there. But stay tuned. So be on the lookout for a live tomorrow. Today's Thursday, right? Yeah. So be on the lookout for a live tomorrow evening, probably around 7. We're going to go live. Gigi may not be with us. She may be taking her camera and her mic, but I don't know. But we're going to do a live where we are just talking to you guys, answering your questions, hanging out with you, which we love to do. You guys are always awesome and support us. Remember to follow us on social media, and also our website. We have some court documents up if you missed something. We have those up, www.prettyliesanalibis.org. And if you want some merch, cool merch, go to www.prettyliesanalibis.com and get you a t-shirt or I think there's hats on there. Maybe not hats. We need to do hats. I wear my Yankees hat a lot. Baseball is back, guys, and March Madness is in like full bloom. Loving it. So, well, that's it for today. Check us out. We will keep you updated, and hopefully you can get on and catch the live tomorrow, the 25th. I think that's right. Yeah, tomorrow the 25th for a live at 7 p.m. So we will see you there. Y'all have a good afternoon.